Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Ann and I are here. Ann is a law professor at the University of Colorado who teaches and researches securities and business law. She holds up the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Let's talk about a couple of recent developments in how companies make life a little harder for shareholders and activists. We have an interesting situation involving Caremark and Paramount, the owner of CBS, among other things. Those are the ones, right, Ann, who just canceled our favorite Stephen Colbert.
Yes. Well, he's still got another year under contract, apparently.
Yes, correct. Well, there's an interesting angle to this where there's a potential lawsuit and so forth that we'll delve into. And then we can also look at how companies make life hard for shareholders with respect to advance notice bylaws, and this is at Cracker Barrel. So yeah, we'll talk about those two things.
Okay. And also just a reminder to our listeners that while we slowly get through our mailbag, we have one. So please, if you have things you'd like us to discuss, you can email us at shareholderprimacy@freefloat.llc. And we're actually going to be talking about one of those emails today when we talk about Paramount and this threatened Caremark situation.
Yes, and we can also mention that we are about to embark on a little bit of a break for the rest of the summer. There are only going to be a couple of episodes posted between now and like the end of August. We're skipping next week. We'll have one the week after, and then probably skip a couple weeks. So anyway, we're hoping you enjoy the rest of the summer as much as we plan to, and we should be back on a full schedule the last week of August. So with that kind of housekeeping out of the way, we can get into the substance of why people listen to us, Ann. How's that?
That's good.
Previously on Shareholder Primacy, we talked about the obligation of directors, at least of Delaware corporations, to like follow the law and make sure their company follows the law. They can't intentionally cause a company to break law, state, federal law. And they also can't intentionally ignore law breaking. And in addition to all the criminal repercussions from that flow to a company, this gives shareholders a cause of action. Shareholders can sue the company, sue the board for breaches of something, fiduciary duty, I suppose.
Exactly, yeah.
For not supervising law breaking at their corporation. And that's come up a lot, I guess, has it not?
Yeah, it's shareholders have brought a lot of claims. I think it actually goes back. This is part of the reason companies have been sort of dissatisfied with Delaware, that some of these claims are getting more traction. So yeah, we talked about the doctrine on a prior show, and one of the things we said was that it's an odd fit for Delaware because law breaking, it's bad, but it might be intended to benefit shareholders. It's often done so the company can increase profits, and it might actually, even if there are penalties in the end, it still may net out to a benefit to shareholders.
We may make a net gain after we've defended someone and sent like a mid-level person to prison.
The vice president in charge of going to jail. Yes,
we might actually come out ahead.
So there's this tension that we treat shareholders as the injured party that has a right to sue over law breaking, even if the law breaking all told ended up with a net positive for the company. And it's awkward for Delaware because it means Delaware has to kind of step outside its lane and act as a regulator and administer these other bodies of law.
Adjudicating criminal
exactly
kind of stuff in Chancery Court. Yeah, right.
Because shareholders can sue even if there hasn't been a finding of liability. So this is the Fox News suit that's pending right now. Shareholders are suing, accusing Fox News of defaming Dominion but Fox News has never been found guilty of defaming Dominion.
Right, they settled that case.
Exactly.
Yes, right.
So if this proceeds, and we'll see how far it gets, but if the case proceeds, it means the Delaware court would have to determine if there's defamation in the first place. So the whole point is that it makes Delaware step outside its lane, and this has been awkward for Delaware. And there were recently headlines. Yeah, sorry.
There was a headline about the Meta, right?
That was about Meta. Yeah. Yeah, because there was a claim against Meta claiming that its board intentionally violated the law by violating users' privacy, and it sort of ate the penalty in the end. But it did this essentially to increase profits, it ignored privacy laws. And the shareholders sued over this. And literally after the first day of trial, it was scheduled for like a really long trial. After the first day, they announced that they were settling. And we don't know the details of that settlement yet. They'll be made public eventually. But honestly, I feel like Delaware itself dodged a bullet.
So that was like a little disappointing, wasn't it?
It was so disappointing for me personally. I was going to enjoy it. But it was like I was getting ready with my popcorn. But
ready to sort of hear how Chancery might have ruled, or at least how the evidence works. Procedurally, it probably would have been interesting.
Exactly.
To how that unfolded.
Because none of these cases ever actually gone to trial, so we don't really know how these intentionally break the law cases play out in trial. But that is actually not the situation that has my attention this moment. What does this moment is Paramount.
Yes.
There hasn't been a Caremark case against Paramount, but one has been threatened. And as I said before, when describing it, I'm actually going to circle back around to a mailbag question we got about the duties of diversified institutional shareholders like mutual funds and what duties they owe to the investors who hold shares of their funds, which sounds far-field, but they come together.
You're going to connect the dots.
I'm going to connect the dots. So we've all heard, I'm sure you've heard about this Paramount merger. Paramount has a dual-class share structure. The controlling shares are held by Shari Redstone. She wants to sell. She's agreed to a merger with Skydance, and it's differential compensation. She gets $2.4 billion in cash for her high vote shares, and the public shareholders get mostly a combination of cash and stock. And the stock is in this new entity that becomes the parent of the old
and
Paramount.
the buyer is Larry Ellison's son.
So is Larry Ellison's son, David
That's who Skydance is, right? Okay.
That's
just in case
is.
people need a reminder there. All right,
Larry Ellison is helping, as I understand, his son buy a media company. But the deal has been stalled because the FCC hasn't given its approval to transfer Paramount's broadcast licenses to this new entity, at least as of this moment. I mean, as far as I know, the headlines today will be they agree.
Right.
But
as of this morning, it hasn't happened, right? Yeah.
It hasn't happened. So just when Paramount was seeking this FCC approval, Donald Trump had this pending lawsuit against Paramount because he claimed that the 60 Minutes show on CBS had deceptively edited an interview with Kamala Harris that ran during the presidential campaign in order to make her look more articulate than she actually was. So he had this pending lawsuit, and every commenter agreed that Trump's claims were legally frivolous. I mean, they were just silly. I mean, just from the idea that the interview...
Oh, like on a First Amendment basis.
On any kind of basis. His original complaint claimed that this was consumer fraud. He was suing for billions of dollars in consumer fraud personally because of a allegedly deceptively edited... It was silly. It was very silly. From the idea that it was deceptively edited at all to the idea that he would have standing to bring billions of dollars in claims. But... also, I mean, everyone denies it, but there seems to be this understanding that the FCC was never going to approve this merger unless Paramount agreed to pay Trump some settlement to resolve these very silly claims. So Paramount did settle it, paid about $16 million to Trump's presidential library. And now Skydance really hopes that FCC is going to approve the deal.
Right. So hopefully the deal will now go through. Now the tribute has been...
Well, it depends on which side you're sitting as far as the deal is concerned.
If you're a Paramount or probably a Paramount shareholder. But
some Paramount shareholders would not like it. But as Stephen Colbert would say, this looks like a big fat bribe. This looks like, as he did say, which is why he apparently no longer has a show, maybe. This looks like Paramount bribed Trump to get merger approval. So as soon as this was reported, the Freedom of the Press Foundation, which happens to own shares in Paramount, threatened to sue as shareholders of Paramount over this bribe. So let's take a moment to think about this. Now, first, I'm not a crim scholar. I don't know what counts as a bribe or not. I'm just going to assume for the purposes of this discussion that there really is a real case that this payment did violate an anti-bribery law. I don't know that it did. I am assuming that it did for the purposes of discussion, that there's a violation of law somewhere.
All right.
It's obvious why the Freedom of the Press Foundation would want to sue, because for them, this is a threat to journalistic integrity. But if they do file a lawsuit, as they threatened, they'd be doing it as shareholders, not as journalists. And this is the conceptual problem with Caremark, which is a rational, economically motivated shareholder might be totally fine with breaking the law in service of profit.
Yeah, there's Paramount shareholders that just want this thing to be...
They just want... Exactly. So you have to ask whether a shareholder really is an interest as shareholder. So that leads to a sort of the hypothetical question, because the suit hasn't been filed yet. Maybe it will be. Do Paramount shareholders have a reason to object to this payment as shareholders, not as journalists or members of society?
Right. Or Okay, yeah, thank you. Exactly.
Yeah.
So is this kind of a cost that we should bear?
Yes,
I don't own Paramount shares, but yeah.
Exactly.
Okay.
And one reason shareholders might legitimately reject is they think it's a crap merger. I mean,
Yeah,
there are already
well,
objections
there's
to the
been that
merger.
talked about. Yeah, there's been some chat that the merger isn't as good as it could have been, but anyway.
Exactly. A lot of the public shareholders are claiming that all the consideration is going to Sherry Redstone and that they should be paid more for their shares. So if you have corrupt payments on top of it to push the merger through, that just adds insult to injury. And there's a merger objection case pending right now that's already been filed, and I would not be surprised to see this whole
Against Paramount.
Against
to object to it on economic
on a fiduciary basis. This is a conflicted transaction. The controlling shareholder is getting different consideration, and it's judged under Delaware's old standards, which makes it easier.
Maybe we'll talk about appraisal sometime soon.
Yeah, we'll have to see what happens if this merger goes through. But let's do a thought experiment. Let's assume that you didn't object to the merger price. Let's say you liked the merger price. Is there a reason Paramount shareholders, as shareholders, would object to this bribe, I say with air quotes, if this payment was the only way to get approval? Well, this is where we get to this question of shareholder duties and diversified shareholders, because Jeff Gordon at Columbia, professor at
Columbia University, not Columbia Broadcasting.
Yes, Columbia University, had a blog post about this. And his theory was shareholders should care, even if they like the merger, because they're shareholders of other companies. And if Paramount executives are allowed to pay this bribe, then that will encourage the administration to make similar demands in other mergers, maybe file more frivolous lawsuits, and ultimately this could be very disruptive for business. But if shareholders successfully sue the Paramount board and establish that boards are not permitted to make these payments, then that means future boards won't be subject to similar demands. Everyone will know these payments are off the table.
There's precedental. Is that how would you say it? Precedental value.
Well,
Okay, go ahead.
Yeah, the idea being that it will establish that boards can't make these payments, and that will dissuade future similar demands from the administration, which is, I have to say, kind of why Trump suddenly declared that the United States wouldn't really be enforcing the Federal Corrupt Practices Act, the Foreign Corrupt Practices. Yeah, he announced that they wouldn't be enforcing really somewhat the Foreign Corrupt Practices Act.
Those are bribes paid to people in other countries, paying to his, not to his presidential library.
Yes, they're bribes to other countries, but it's not great for American companies when you announce that, because American companies like being able to say to foreign governments, we can't bribe you, it's illegal under American law. And when you announce that you're not going to enforce that law, now it's very hard for companies that do abroad in foreign countries to say, we can't pay you, it's illegal under federal law, because those countries can say, well, didn't your president just say he doesn't care anymore? So I don't know. But
he likes bribes. He's okay with it.
But anyway, the thing that's interesting about this argument that Paramount shareholders should care about it because they are shareholders of other companies is that it's not about maximizing value at Paramount. It's about maximizing the value of a diversified portfolio that includes Paramount. The argument is that shareholders of Paramount might forego or delay valuable merger consideration in order to maintain a corporate system that's overall beneficial. Right. And the reason this struck me is because this is an idea we talked about on the show before when we talked about the McRitchie versus Zuckerberg case. So that's another show we did where McRitchie alleged that Facebook's board was violating its duties to shareholders because the board made decisions that maximized Facebook's profits at the expense of the broader economy, which ended up harming diversified sharedholders who held shares in other companies.
And that argument didn't get very far.
It did not get very far.
Laster, but yeah.
Yeah, exactly. The court did what the only thing the court could do, which is reject it. He held that Vice Chancellor Laster held legally a board's duty is to care only about one company, not a diversified portfolio. But that leads to the mailbag question, which is, what about the diversified shareholders? If you're an institutional investor like BlackRock and you hold a diversified portfolio on behalf of investors in your funds, must you, as a diversified investor, make voting decisions, and I guess lawsuit decisions, based on what benefits the portfolio overall, even if those decisions aren't wealth maximizing at a particular company? So that was actually our mailbag question. Does BlackRock have to care about the diversified effects of the portfolio? And the answer I give, with Paramount as sort of the jumping off point, is Yes and no.
Yes, and maybe.
Maybe. BlackRock does. I think that's right. It has a duty to maximize the value of its funds. And that could theoretically mean, like Jeff Gordon argues, reducing systemic risks, even if doing so doesn't benefit individual companies, like climate change. That's a systemic risk. If you reduce it, you benefit a lot of companies. BlackRock might have an interest in combating systemic racism, which costs the economy trillions of dollars overall, even if the benefits at one particular company aren't particularly big.
Are high, yeah, right.
Yeah, or the costs are high at one. Yeah, exactly. Right. But the rub on that argument is, and we talked about this when we talked about the McRitchie case, BlackRock doesn't hold one big fund. It holds lots of different funds.
Right, they
with
have
different
many different interests and many different,
and some might be vulnerable to different systemic risks. So if BlackRock is going to seriously think about the systemic risks that affect a diversified portfolio, it would have to go on a fund-by-fund basis, and it's not clear that it really can do that, that has the information to do that.
That would be like impossible. I mean, it's not impossible. That would be a real hassle.
It would be very complex. So now that said, and this is an argument again Jeff Gordon has made, we can see today that the structure of public companies really does bend toward what diversified shareholders want. So for example, today companies take on a lot of leverage to make cash payments to shareholders. That's what you want if you're diversified, because you're not concerned about the risk of any one company. The conglomerate, which was justified as a sort of, to some extent, as sort of a risk reducing measure.
It diversifies risk, right?
Yeah. That's died out because shareholders can diversify. You don't need the company to diversify.
Right.
So in many ways, the structure of the public corporation today does take the preferences of diversified shareholders into account. But so that's my yes or no question answer to the mailbag. But I will finish with say, even if it is better for diversified Paramount shareholders if they sue the board for bribing Trump.
And invoke Caremark, right?
Yeah. Even if they did, they have another problem standing in front of them, which is that the shareholders of Paramount will not be shareholders of Paramount once the merger goes through.
Right.
They're going to be holding cash, or they'll be holding stock in a new entity, which will be the parent of the old Paramount.
They won't have, as we say, standing.
They will not have standing. That's exactly right.
They got to sue kind of soon.
Yeah, even then they lose it. Even if they filed the complaint tomorrow, they would lose standing once the merger goes through, because the point is that this injured Paramount. You're suing as a shareholder of Paramount, saying that this injured Paramount. But you only have standing to make that argument as long as you're a shareholder of Paramount. If you're not a shareholder of Paramount anymore, you have no standing to make that argument. So if this merger goes through, any time on what the timeline for a lawsuit will be, it's very possible they'll lose standing. Now, there are some arguments around that, so I don't want to prejudge what strategy they might adopt, but it's a real hurdle that stands in their way, that on the eve of a merger, it's very hard to bring a derivative lawsuit on behalf of the company.
Yes, that's happened before.
It's happened before. They've lost standing along the way. But I'll just finish with, I don't think this issue is dead, because when we really see the actual merger objection get litigated out, I would be surprised if those plaintiffs didn't fold this in.
So to include,
because they just don't like the price.
The allegations that this is a bribe, and that's going to be complicated anyway, whether the settlement of lawsuits a bribe, but that'll be
right.
That'll be fun to hear.
I mean, I was assuming it's a bribe for the purposes of this call.
Right. Yeah, we talked. You made that stipulation, as we said earlier. Wow. Yeah. So we'll have to follow this, because there's we'll see who sues who over what, including possibly the Freedom of the Press Foundation. I mean, but also,
how this merger objection
and
plays out.
And there may be others that come up. Wow.
Yeah,
All right, so maybe you'll get your Caremark trial after all.
Some version of something like it. We'll have to see.
All right. Well, let's think about that a little bit during the break, and we can then turn to the other subject we wanted to talk about. How's that?
Okay.
All right. Here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we are going to talk about Cracker Barrel. So what's going on?
Have you eaten at a Cracker Barrel?
I don't believe I ever have. It's like a southern thing.
Yeah, all the time you lived in the South, you never.
I live now in Louisiana for. Louisiana. I'm sure that they have them, but Louisiana It has very
Yeah.
idiosyncratic chains. 'Cause
Yeah,
it's,
so-
you know,
So I haven't eaten one in quite a while. It's it's kind of old timey. They have this enormous gift shop, and it's kind of like highway rest stop kind of stuff.
right.
But it's Cracker Barrel. It's a nice place. It's good. Food's decent. But Cracker Barrel's a public company.
Yep.
They have a shareholder who's really kind of interesting. And they don't like that shareholder very much for reasons we're about to hear. And so they pioneered a couple of new ways to kind of make life hard for that shareholder and potentially for all us shareholders.
Boards are endlessly creative.
Aren't they? Yeah, they're really resourceful here. So Cracker Barrel, a couple months ago, approved amendments to its bylaws and the advance notice terms of its bylaws to do two things. And then we'll get into kind of the why and how this might matter to the rest of the world as we talk about it. The first was it basically requires an activist, you could say dissident, we'll just say activist here because that's really who's doing it, to get a material amount of support in a given proxy contest in order to continue to do further proxy contests.
Right. So go on.
So you got to get hit some sort of minimums, which we'll talk about.
So it's about repeat contests.
It's about serial or repeat. Yes. So if I run a proxy contest at Cracker Barrel now, but potentially other companies, what do I need to do? What kind of success do I need there in order to do it again, like the next year or the year after that or something? And then the second bylaw amendment had to do with reimbursement of proxy contest costs. And essentially, they're going to require an activist who sort of fails to get certain amounts of voting support, require that activist to reimburse the Cracker Barrel for Cracker Barrel's proxy contest costs. And then in fairness, they decided to write that bylaw amendment in a way where Cracker Barrel will also reimburse the activist if the activist succeeds in certain ways.
But that's also for repeat contests. It's not like the first.
Yes, correct.
It's not the first
just
bite.
the
It's the
first
second
one.
bite.
It's for repeat contests, and that'll become important to our discussion about whether this kind of has legs. But before we talk about those, it's worth kind of setting the stage about the players. Because they're really interesting. Well, I mean, Cracker Barrel's not that interesting. I mean, Cracker Barrel is, it's just a restaurant chain. It's done okay. Its shares are up this year. Shares are down, last 4 or 5 years. It's got the usual board of directors and some entrenchment, blah, blah, blah. Its shareholder is kind of fascinating in sort of a perverse way. Its shareholder is a company called Biglari Holdings. Have you ever heard of Biglari Holdings before?
I have, but only because they've I think they once got into trouble filing an HSR notification when they increased a stake.
Well, they
in
might
the
have.
company. It might have
I
even
mean,
been
they've been all over. Biglari Holdings is a really weird. It's a public company, trades under BH. It's run by this guy, Sardar Biglari, who is the CEO. It's based in San Antonio, Texas. I think he's in his early to mid 40s. He's been running it for 10, 15 years. So he started it when he was quite young. He kind of fancies himself as sort of the next coming of Warren Buffett. Okay. He's got this kind of non-financial holding company that owns a bunch of operating businesses. He's got some insurance subsidiaries that throw off cash. He doesn't take any comp the way Warren doesn't. The website is very sparse, and of course there's the initials BH, which also is Berkshire Hathaway. So there's a lot of apparent, potentially deliberate similarities. And the businesses he runs are Steak and Shake, which was kind of his original really successful turnaround in an activist situation. That worked out really well. He owns a company called Western Sizzlin', this little kind of restaurant chain that wasn't such a great activist situation, but he eventually got it. Got some oil and gas companies, those insurers. He also owns, you remember Maxim Magazine?
No, I am aware of it, yes.
Maxim Magazine. He owns that. And evidently that's part of the, it's I think it's probably past its prime now. There's all sorts of other better ways to kind of get that kind of media. But anyway, he owns Maxim Magazine. BH has done kind of, over the past like 10 years compared to Berkshire. So that's Big Larry. And they've done some activist stuff. Right now they have an activist project going on, potentially at Jack in the Box and also Pollo Loco, just 2 other restaurant chains. And so he's just, Sardar knows his activism. He's, knows bylaws, he knows boards, that kind of stuff. He's also been a long time, I'm going to guess, irritant at Cracker Barrel. He has run no fewer than 6 proxy contests.
Oh, wow.
At Cracker Barrel. 4 in a row from 2011 through 14, another one in 2020, and then one in 2024. He hasn't won a thing there.
Yeah, so it sounds like these are unsuccessful because
he hasn't got right. I mean, his vote totals have ranged. I mean, one year it got like tiny, but it's basically between 10 and 30% of the vote for him and potentially one other nominee. In 2011, he ran. He demanded and won because he had enough shares a special election, and the agenda item was to see whether the company should sell itself, and the agenda item failed. So anyway, so you could sort of see if you're Cracker Barrel.
That's the thing about Cracker Barrel that I think it's with 20% you can call a shareholder meeting.
Right, correct. Like you're right. Yeah. Though interestingly, Cracker Barrel is a Tennessee corporation. Yeah. So I don't know how much Tennessee corporate law you've dug into.
I don't know that Tennessee knows what its corporate law is, but yeah.
Right. So anyway, so there's various rules there. So anyway, so that gets us back to the advance notice bylaw changes, which are worth kind of delving into for a second. So the first one was you need sort of a minimum vote. So and Cracker Barrel kind of designed this clearly with Big Larry Holdings.
Yeah, they aimed a bylaw at Big Larry that doesn't actually say Big Larry in it.
Okay, so essentially, in a given AGM, if a nominee, so this particular bylaw is nominee centered. If a nominee fails to win at least 20% of the votes cast, that nominee is precluded for standing for election at the next 3 AGMs. If that nominee wins between 20 and 25%, that nominee can't stand for election at the next 2 AGMs.
So this is named people named Big Larry who nominate themselves.
Or I mean, it could be people named Levin or Lipton too.
But right, no, but it means that
it's for people.
Yeah.
Well, so here's what happened is that, and it also, I mean, I suppose this was legally proper. This also applies to incumbents, too. It applies to anybody who's running.
Right.
But incumbents, of course,
it's even. It's even. It's whoever the nominee is, board or not. If that nominee gets these low votes, they have to take a pause.
And if you're precluded, that shareholder can nominate others. So this applies to the nominee. Well, as it happens, this works retroactively. So the bylaw was passed like in May of this year, but it applies to it applies to the AGM from 2020 or 2022 or 2024. Well, in 2024, Sardar Big Larry stood for election to the board and won 18% of the votes. Well, 18% is less than 20%.
He personally can't run himself for director for another 3 years.
In 2025, and that AGM already happened. So really 2 years, 26 or 27. So he now personally cannot, if this bylaw is enforceable, we'll talk about that in a minute. He personally cannot run for the board at the next 2 AGMs, assuming they're in 26 and 27. All right? So let's talk about the reimbursement one, which is even a little more interesting. Okay? For an activist, again, so now we forget the 20% threshold. This is a straight 25% threshold. Right. So this applies to the shareholder, not the nominees.
Right, if the shareholder who's sponsoring a nominee.
Yes, correct. The shareholder who's making the nominee, which could include himself, as Big Larry Holdings did, but anybody else. Okay, but this is the shareholder. So this is Big Larry Holdings, but we'll take them out of this for the moment. If all of that shareholders' nominees fail to win at least 25%, okay, then, so we're going to mark that. Mm-hmm. Then at the next AGM, when that shareholder nominates directors again, if all nominees again fail to win at least 25%. Then, so it's 2 in a row, the activist has to reimburse Cracker Barrel for Cracker Barrel's proxy costs up to a limit of $5 million, which is a lot of money. That's I don't know. I mean, I didn't look what Cracker Barrel hasn't spent them, I don't think, and I'm pretty sure Big Larry hasn't either. So anyway, so they're going to try to collect that from the shareholder again if the second proxy contest fails. Okay, fails to win, and again this works the same way. If the shareholder wins at least in that second proxy contest, if they win a seat, then Cracker Barrel reimburses the shareholder for their expenses, again, up to a limit of $5 million. Mm-hmm. So, if you get over 25% but don't win any seats, I guess between 25 and 50 or whatever, depending on how plurality voting works, then we're just we'll call it even.
Yeah, and this is after an unsuccessful contest.
Right.
The next one, you have these reimbursements.
So let's go back to Big Larry in 2024. Mm-hmm. Okay, again, Big Larry won 18%. Big Larry Holdings, not Sardar. Right. Well, Sardar, but Big Larry Holdings, the shareholder, won 18%, which is less than 25%. So if the 25 meeting is passed, if in 2026, Big Larry Holdings nominates directors because of what happened in 2024, because this is a 5-year period, and Big Larry Holdings nominees each together fail to win at least 25%, then Big Larry Holdings will need to reimburse Cracker Barrel for its proxy contest costs.
But if they win.
Oh, if they win, Big Larry, right, absolutely.
Yeah. So it's just such it's just so interesting, and it's so geared directly at this repeat issue. There's no cost sharing, shifting, or any kind for the first contest. It's only after a failed first contest that's not just failed, but failed a lot.
Right. So there's actually I have several questions, and maybe you can help with some of these. First, how would Cracker Barrel plan to collect? Suppose in 26, Big Larry does this and fails and owes him $2 million for whatever, 5, I don't know, maybe.
Well,
maybe
a lot of courts treat these bylaws as functionally a contract. So
that's a question. Claim. Okay. Oh, interesting. Okay.
I mean, I wrote a whole paper, more than one paper. I don't think they should be considered contracts. That doesn't necessarily mean this would be enforceable, but a lot of courts increasingly are saying, is this a contract? Now, I've never seen it work as a contract to then be able to sue the shareholder for costs. But if you extend the logic out, how does your answer change if the advance notice bylaw terms were just amended along to provide for the reimbursement to also include in the notice letter that the shareholder commits to set forth an undertaking, that's in sort of air quotes, that the activist will reimburse? Then that becomes part of the bylaw, affirming it. Yeah. So that's another way, I guess. Like, it could be as part of, like, in the same way you have to fill out a questionnaire, you have to disclose who your sponsors are, you have to not be hedged or whatever the other. Another one would apparently be you have to actually write out an actual promise. So
evidently that's in the notice letter that I will pay you for. I guess so. Maybe that strengthens the contractual nature of this presumed agreement between the parties.
So then you would sue, the way you collect is you sue as a contract claim.
Right, you sue to collect, of course. Sure. Okay. I mean, because, I was thinking maybe should Cracker Barrel require a bond? Do you need to send a $5 million bond in with your notice letter?
Well,
I have wouldn't that be
idea.
Well, anyway. So my second question is this even legal? Can companies do this? Can Cracker Barrel do this? Will Tennessee allow this?
Tennessee, who the hell knows?
And wait a second. Everybody, all our listeners know, none of this is legal advice. So no one.
It's Tennessee, so we don't know. So I fall back on Delaware, and my answer is I have no idea. So first of all, when I look at this, what Delaware, I've never seen anything exactly like this. Certainly not. One of the things to note about it is that it's really narrowly tailored at one shareholder, certainly. But also, I would say, at a particular problem, like, and it depends on what you frame the problem as. The problem does not seem to be the board afraid of losing their seats, which is usually the issue. The problem is literally just the expense and headaches of having to constantly
and the
fight
hassle
off
of having to deal with this
guy who doesn't have shareholder support, who is actually draining essentially company resources with repeated failed challenges. Now, if you frame it that way, and I don't think that's unreasonable, I think the board has now pretty well established that they don't have any actual fear of losing their seats from this. If you frame it that way, then you, under Delaware law, if that is the threat to the corporation, the threat that they are defending against isn't, oh, we don't want to lose our seats. If the threat is unreasonable expenses being inflicted on the company.
Right.
Then the question is,
hassle on shareholders having to vote. Shareholders,
exactly.
The first 3 times, shareholders probably could have had a conversation with Starter and said, okay, do you get it now? We don't want you here.
So if you frame that as the problem that they're defending against, then this, I gotta say, and as somebody who's pretty, sympathetic to activists, this looks like a pretty tailored solution.
Yeah, it seems.
It's specifically aimed at repeat contests, not initial contests. It requires, the only way it kicks in and inflicts any pain is if somebody gets, not just doesn't win, but seriously doesn't win in the repeat contest. To some extent, they're eating their own cooking because their own nominee. I mean, I don't know how many their own nominees can't stand for re-election. So, and given the history that they're defending against a very real, specific threat, it's not obvious to me that this would be a problem under Delaware law. Now, what you are not allowed to do is adopt an advance notice bylaw for the primary purpose of interfering with a shareholder vote. But I think there's a case that is not what this purpose is.
It's not what appears to be happening here.
I'll note that this framing of timeout if you don't get if you don't get a lot of support, that's taken directly from federal law, the 1488 rules.
Yeah, that's. I was going to say that there's a very relevant precedent, though it's not around director elections, it's around directory proposals.
Yeah.
Where you got to keep increasing your support, or you're not allowed.
Yeah. Yeah, exactly. So. And it doesn't kill you if you just don't win, but if you don't win by a significant amount, then you get timeouts. Right. So it's not obvious. And I'll also note, and this is why I mentioned that they allow shareholder meetings, is that I don't think it's required under Tennessee law that as I understand Tennessee law, and I don't know that anyone, but I certainly am not sure that I'm right. But Tennessee law has a default requirement that you allow shareholders with 10% to be able to call a meeting, but you can change that in the charter. And I think that means, I don't want to swear and stick, but I think that you might be able to therefore get rid of it, which means if they are allowing shareholders to call meetings with 20%, that's a choice. Meaning, and it's a shareholder-friendly choice. They're allowing shareholders to call meetings.
Right, sure.
So it's not like this is a board that, is being draconian in general about defending against shareholders. So my instinct is that this precise set of bylaws, given this precise context, Delaware is very sensitive to, well, what was the threat? Did you really identify a threat? Was it an abstract or was it real? Would be okay. That's my guess. But I don't know for sure. But of course, if they were to, you start varying it, you start making it to not just repeat
right. That's
players.
The thing. Is that the interesting thing to try to think about is our company's going to kind of copy this.
Yeah, and if they do,
and what would that look like?
And then that's when we'd start to get if they don't well, first of all, I don't know how often. You tell me How often is it that somebody does repeat contests, especially especially with losing by this much?
Maybe a couple years in a row.
Yeah.
But most activists,
they're in it for the money.
After two,
two with really low support. I mean,
Right, yeah.
So it strikes me that they're dealing the reason this particular set of bylaws in this particular situation doesn't bug me is because it looks so specific to one particular actor who really is inflicting costs on the company. But if other companies try to copy it, they're not going to be looking at the same situation. And what I'd be worried is that they'd be tempted to broaden it, to make it
or make the thresholds a lot
make the threshold a lot higher, make it suddenly reverse the cost reversal on the first failed contest rather than the second, and on and on.
But
I could see that.
But the securities, the bylaw drafting bar loves this stuff, and they're gonna. I mean, so there's, conceivably going to be numerous meetings this fall when boards start to say, what should our bylaws look like, where, some of these big firms are going to say, hey, did you see this?
And they're going to, that's what I would be sort of looking out for. Like, do other companies try to do this, but much more, much less in response to a very specific problem and much more aggressively proactive.
And if it happens, if somehow there's this, bunch of companies do it, again, most activists aren't necessarily going to worry too hard, because you got to be really a serial. There's going to be companies that are. I mean, it's symbolic. There are companies out there that do anything they can to make life hard for activists, and this could be part of it. So anyway, wow, it's good. I'm glad I asked that. I was kind of wondering how it would, what Delaware might think of this or something.
Again, just my guess.
And I think it's a very good educated guess. Not legal advice, not investing advice, but a good educated guess. All right, cool. Shall we wrap up, Ann? I think we've done this enough. Let's do that. Terrific talking to you once again about all this stuff. We will kind of return to advance notice bylaws probably a little later in the year. A couple quick reminders, as we said. Send stuff to the mailbag. Shareholder primacy, one word, at freefloat, one word, .llc, and we will consider your questions carefully and maybe read some on the air. And then second, we're going to be taking a little bit of a break. There'll be probably one more podcast posted sometime in August, and then we will resume the last week of August. So we hope everyone has as good a break as we're planning on. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the incoming professor of law and Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School. You can find me, Mike, at theactivistinvestor.com and Ann at new website, lawweb, one word, lawweb.colorado.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We'll talk again soon.